Hello everyone, I'm George from Ireland, so welcome back to my English Law channel. So I'm carrying on looking at settlement, trusts for sale and trusts of land. So in strict settlements, let's look at a tenant for life and the roles and rights of various parties in these settlements. So tenant for life is anyone who's over 18 and is beneficially entitled to possess the land. That's as per sections 19 and 20 of the Settled Land Act 1925. Now, it's unusual when there's no tenant of life, or indeed the tenant of life is a child, in which case the legal estate is vested in the statutory owner. That means the trustees of the settlement. After 1925, legal estate and the statutory powers were in the same person. Normally it was tenant for life, and this person would hold these on trust for those who were entitled under the settlement. So the tenant for life had broad powers. The main one of these is that they could sell, lease, or mortgage the land, and these were exercisable if they gave notice to the trustees of the settlement. But there are some statutory restrictions about this, about how they can exercise these powers as per sections 41 and 42 of the Settled Land Act 1925. Dispositions which are not in consonance with the provisions of the Act are declared to be a nullity. But if the tenant for life acts bona fides, say in good faith, then neither the trustees nor the court can do anything to block what the tenant for life is doing to exercise his or her powers. So the prerogatives of the tenant for life cannot be assigned, and the settlement can give this person extra powers though. So a provision designed to reduce their powers is again a nullity as per section 106 of the Settled Land Act 1925. So there is a provision saying that a tenant for life is to forfeit his or her residence and to stop living on the settled land. Now, if the tenant for life stops residing, as they're meant to do in exercise their statutory powers, for instance, they sold the land, the proviso, again, is declared to be null. But if the person stops living there for some other reason, then the proviso operates, and their interest determines. There's a case about this, Ray Ames, 1993, or Ray Acklum, 1929. So sometimes there's a residence condition, so the tenant for life actually has to live on the land. And these can be enforced more efficiently if the land is settled on a trust of land. So let's look at the trustees of the settlement. So section 30 of the Settled Land Act 1925 says who the trustees of the settlement are going to be. So in legal estate and settled land is not vested in them as trustees, but they have some key functions pertaining to the settlement. So they have to give their say-so to particular transactions if they're going to take place. They must be informed by the tenant for life if there is an intention to perform certain transactions. Further, they receive and they hold the capital money, as in the money that comes from selling the land, leasing the land, mortgaging the land, and they must use it in some other way set out by the Settled Land Act 1925 as per section 73, in coordination or in agreement with the tenant for life. Okay, so let's look at someone who's purchasing settled land. So someone's buying it, doesn't have any right to see the trust instrument, and is entitled and is indeed bound to assume that the details in the vesting deed are correct. That's as per the section 110 of the Settled Land Act 1925. So someone who's buying bona fides and with the tenant for life is taken against the other parties who have rights under this settlement to pay the best price. They've got to get the best price that you can, and then that will be you complying with the Settled Land Act sections 110.1. So if the purchase money is paid to the trustees in settlement, or indeed to a trust corporation, or sometimes into a court, whatever the tenant for life prefers, then the buyer gets valid title. The beneficial interests under the settlement are thereby overreached, and then these are transmogrified into money from selling the land. So the overarching scheme is obvious, it's easy to understand. The beneficiaries are protected by the requirement that the buyer has to pay the money to the trustee of the settlement, and the purchaser is protected so long as he adheres to the provisions of the Settled Land Act. Now, there are a number of anfractuosities arising from settled land. The strict settlements, they're an anomaly, some strange type of trust, and the trustees had very few proper powers. So the important powers were given to the tenant for life, who was the beneficiary. So this is really antique, the way that there were such limitations upon the life tenant's ability to make a disposition of the land apart from selling it. For example, he couldn't lease it for over 50 years. And he was unable to mortgage the land for an important reason. For example, he needed money so he could improve the land, digging drainage ditches or building something, or whatever. That was very, very restricted. It was effectively impossible to do. A lot of paperwork was required. It was a real headache, Byzantine in its complexity. And the verbiage in the Settled Land Act was really anachronistic. So many barristers and solicitors tried to circumvent these things, which is not create strict settlements. Strict settlements were sometimes created unintentionally, especially when somebody wrote his own will and didn't use the right terminology, didn't know what he was doing. And they would then set up these successive interests. For instance, giving my property to my wife and then to our daughter, and so on. The wife in that case would have the power to sell the house as life tenant, and nobody would be able to forfend it. So let's look into trusts for sale. After 1925 and before 1997, there was an express creation of an immediate binding trust for sale, and that was the way people got around creating strict settlements because they didn't want to do that. So trust for sale gave the trustees the duty to sell the property, but they did have the ability to delay sale indefinitely. So this was a very strained and false way of approaching land holding. The equitable interests were behind the trust, and these were meant to come out of the proceeds of the sale and not to the land itself. But anyway, there was overreaching here. So the agreement of named people was needed for sale, and sometimes it was up to them to make sure to make this selling the land difficult, indeed impossible. They wanted to avoid it forever sometimes. But however, the primary duty of the trustees was to sell the land, and they might feel they're somehow failing if they didn't, even though that's what actually wasn't wanted by the settlor or the testator. So if one trustee wished to sell the land and the others didn't, he could railroad it through and it would be sold, because, of course, that was the express purpose of the trust. Anyway, so Section 30 of the Law of Property Act 1925 said the courts, they have latitude on this one to judge whether the sale should be imposed in spite of other trustees not wanting it to go ahead. So there's an awful lot of case law on this one. How should the court weigh the desire of beneficiaries to do different things, to sell the land or to live on it? And then until 1945, it was said the beneficiaries had no right to occupy the land held on trust for sale. They might be allowed to have it, but that was a privilege, it wasn't a right. So Lord Denning sat in a similar case in 1955, which changed things. And he found that the beneficiary did indeed have the right to occupy the land. And everybody says, yeah, that's correct after that. But the real rub with the trust for sales application to land law is that the premise just doesn't make any sense if we're considering family trust of land. A duty to sell, and this doctrine of conversion, as in the beneficial interest converts into money, and saying the beneficiary doesn't have the right to occupy the land. And that's just kind of unrealistic. We've got to consider what the situation is, because land is somewhere you can live. It's not simply something of pecuniary value, and it may well have sentimental value. That's enough for the moment on trusts for sale. Toodle pip.